Broadcast is now starting. All attendees are in listen-only mode.
Okay, it looks like we have, I think, most of the people that are registered, and if not, there may be people joining us throughout the session, but I think we're going to just jump right into it. Real quick, my speaker is turned up as loud as it can be, so if you're having trouble hearing me, try to adjust the volume on your computer and just send me a message if you're having any problems, and I'll try to see if there's any way we can correct it for you. Good evening. Welcome to the Micklin Law Group's webinar um, titled Divorce Planning Strategies, Myths, and More. My name is Brad Micklin, and we're going to start the session. Okay, so today's webinar, as I said, the title is Divorce Planning Strategies, Myths, and More. It's intended to be a 1-hour presentation. It could be a little longer. It may be a little bit less. I never really know. I come in with certain materials that I want to cover, and I will get through all of it. I just don't know how quickly or how long. I plan to stay until it's over, obviously, and give you all the information I think is important for you to have. You're welcome to stay as long as you need. You can also check in and out if you need to take a break and then come back. I will be here for at least an hour. Afterwards, I will be taking questions. Now, this recording, it's a one-way recording, so you can hear me, but I can't hear you. But you'll notice you should have a pane on the right-hand side of your screen that allows you to type in questions. Feel free to type them in as we're going through. I may type answers back while I'm giving the session because I can speak from the material and also type some responses to you, so you don't need to wait until the end. I may also just address the questions at the end. Depends, I guess, on the nature of the question and how much time that we're having. This webinar is being recorded. It will be available if you want a copy of it. I think you'll be getting, or I think you got a question beforehand asking if you wanted a copy of the information. If you did not respond that you wanted one, but you do decide that you want one, you can just send me an email or send a post as a question asking me to send it to you, and I'll certainly get it to you as soon as it's completed. And lastly, you'll receive shortly after the session, I don't know if it's immediately or if it's maybe even the next day, but you'll receive a survey asking you about the presentation. I'd really appreciate if you take a few minutes and respond to it. It helps me to evaluate the presentation as well as help me with future ones, what's needed, what's good and what isn't, and what's working for people. Okay, so for those of you who don't know me, this is me. My name is Brad Micklin. I am the managing member of the Micklin Law Group. I've been practicing law for a little over 17 years now. I began in, I think it was 1996, working as a judicial law clerk for the Honorable Eugene Austin. He was the supervising judge of special civil litigation at the time, which means we handled high volume civil litigation, landlord, tenant, and small claims cases. It was a really good experience. It gave me an opportunity to learn what happens sort of behind the bench, what judges do with papers and letters, and how they react to different things. So it gave me a lot of good insight. From there, I went to David Kessler and Associates, and I practiced complex commercial litigation for a couple of years. Again, the experience was very helpful. Commercial litigation, complex commercial litigation is very similar to that which we do in a lot of divorce cases. So the background was very helpful. I moved out of that practice because I didn't really enjoy working and representing companies. I much prefer to represent and help people. So I transitioned to my own firm, and I think it was 2001. We are concentrated now in divorce, family law, and estate and probate litigation. We have two additional associates, Rachel Isaacs, who is our senior associate, and Richard Muglier, who is our junior associate. We have various support staff members, Jacqueline Day, who is our office paralegal, Carmen Figueroa, who is our client service manager, and then from time to time we'll also have various administrative staffs so that there's always an office complement to assist any client with issues that may come up. Okay, let me give you a quick disclaimer, give you an idea of what this seminar is and is not about. It is not about hiding assets. It is not about covertly keeping things from your spouse or from the court. If that's what you thought you were here for, you might as well just hang up now because it's not going to happen. It's not appropriate, it's not ethical, and for reasons I'll explain later, it wouldn't help. So let's talk about what this is about. It's about preparation. Divorces are usually very, very taxing experiences for people. They are very emotional. They are very lengthy. They can be very costly. And you're dealing with some of the most important and difficult subjects of your life. You're dealing not only with your finances, but your family and your children. So in order to really handle the case well, you want to do as much preparation as you can. The purpose of preparing is for protection. There's nothing wrong with being ready and preparing and protecting yourself, as long as it's not at the disadvantage or harm of other people. And it's about fairness, and that may surprise a lot of people. But the process itself, believe it or not, is about fairness. It's a sort of about an equal or equitable division of your property, of your assets, of your support. Judges strive, and again, many may not believe this, to be fair to everybody. The problem is it's difficult for one person to see what can be fair to the other side. And that is part of the reason why we have a neutral judge who sits in the middle and tries to balance this. No one party is favored, excuse me, no one gender is favored. We'll talk about this a little later, but really the system does try to work through a fair resolution to your cases. What this is not about, it's not about fraud. It's not about hiding assets or not disclosing your assets. The most important thing to take from this seminar is even if you wanted to try and do these things, it's not likely to be effective. Most of these issues, if you try to conceal assets or obligations or valuable property, it will surface somewhere. Most will appear on some sort of document. Any asset that you have or had or transferred will appear on some sort of document somewhere. If you take money out of bank accounts, it's going to show up in your statements that have to be disclosed. If you've sold or transferred property, there's a very good chance it's going to be picked up on a tax return. Even if you don't have, let's say you had an account that you close the account, but past tax returns will show interest statements for those accounts. Retirement accounts, if you close them or take money out, will trigger taxable consequences. Your statements will also show loans. So most of what an average person has to try to transfer or conceal would surface and be disclosed, and you'd actually be at a severe disadvantage for having tried it in the first place. There's also statutes a little broader than this topic is that talk about fraudulent conveyances and sanctions for people that try to avoid their creditors knowing about their assets. And most importantly, if you do try to hide an asset and it's later disclosed, it's going to have a very negative impact on your case and on the judge. Judges are allowed to, by the rules of court, to draw adverse inferences against a party for certain reasons. So if it is discovered that assets were concealed or transferred or something fraudulent was conducted, the court's going to draw adverse inferences about not only those assets, but maybe overall issues about the case. Lastly, and I may repeat this throughout, as I give you some ideas of how to prepare yourself for a divorce before it actually happens, one thing I want people to be mindful of is these actions in and of itself could actually trigger a divorce case. If you're planning a divorce case because you believe your spouse may be filing, and perhaps you're wrong about that, but your spouse sees that you're starting to do the things that I advise you in this seminar, then your spouse may believe that you, in fact, are the one planning or filing a divorce, and that may trigger your spouse to file when he or she may not have actually intended to do so. So a little bit of a balancing act you need to do. If you're the one who's certain that you're taking this step, then the seminar is going to help you a great deal. If you're trying to prepare yourself because you're concerned your spouse may be filing, it's a sort of balancing act that you need to take and just that risk that you need to be aware of. So first, how might a person know if their spouse is planning for a divorce? It often takes a good deal of time to start a divorce case, whether or not you have a lawyer. There's a lot of documents that need to be prepared and filed. And once it's filed, you may not even receive it for a couple weeks or sometimes. So, but many people will plan for divorce before doing so. And often that is going to be the adverse type of planning that I talked about. And you need to be aware of the signs to prevent that or to protect yourself against another person's adverse planning. So the first one to look for is, again, advanced planning. Now, this is difficult to identify because it's usually covert. Um, so what you need to do with regard to this is you need to just sort of listen and pay attention. Um, are the conversations that you're typically having changing? Are attitudes changing? Are habits changing? Um, is your spouse complaining about money all of a sudden but hasn't made any changes in their spending? Are they looking to downsize your lifestyle? Issues like moving into a smaller house or getting rid of a car, or just the opposite, getting a new car before one's actually due for your other spouse. Um, has mail changed? Are you getting new statements in the mail? Are you not getting mail? Have they maybe diverted statements away? You used to get mortgage payments, for instance, and now you don't. Second is minimize earnings. Obviously, this would be the higher paying spouse or the supporting spouse. Did they routinely have overtime that now has mysteriously disappeared? Are they changing jobs or talking about changing jobs? Are they passing up opportunities that in the past they might have taken? Are they delaying bonuses? This some companies and some individuals have an ability to defer a bonus, and a lot of times companies will give you the choice so that it's whether or not it's going to fall in a certain tax year. So you either get it maybe in December or in February. So some people do have the ability to defer. So if they're getting bonuses at different times than they used to routinely, that could also be an issue. And then the last two, decreasing assets and increasing debts. Are there any sudden changes in your asset structure? Like I mentioned before, are we trading in cars and getting a new lease? Are we selling an asset to pay off debts? Are we separating assets? Did we used to have a joint account and now all of a sudden your spouse has a separate account, or they no longer want to contribute the paycheck to the joint account? Increasing debts, again, are they using credit cards more often? Are they increasing the charging that they put onto these cards? Are they giving less money to the dependent spouse for spending and saying use credit cards? Have they mentioned bankruptcy? These are all signs, again, not necessarily, obviously, that a divorce is in the making, but there are certain things to be aware of. And if you see, several of them, the more you see, the more likely that there is something brewing. And this is more important for the dependent spouse. If your spouse is what we call the breadwinner, the higher earning spouse, you really need to watch this. And even if you're employed, many households have two incomes now, but one often is substantially different from the other. Similarly, you may have one spouse that is completely responsible for managing all of your finances. They do all the banking, they pay all the bills, they file all the tax returns, they just give you documents and you sign them. You need to start paying attention. If that's the case, you need to start paying attention to these documents, to what you're signing. You need to ask for copies for tax returns. Now, it may be a little unusual when you start asking for these documents, but you need them, so you need to ask for them. I find a lot of people still come to my office completely unaware of their financial situation. They often don't know what their spouse earns. They don't know what their tax returns say. They don't know how much money they have in the bank or where they bank. And it really causes a problem because you have to get all this information. If you don't know the information in the first place, then you're almost at the mercy of accepting your spouse's information about what your assets are and how much your earnings are. You really need to know for yourself. Even if you're not filing for divorce, I think it's healthy for families to fully understand their economic situations. Last thing to be concerned about in the divorce, and this is a greater need for planning, is if you have a self-employed spouse. I call this the pizza parlor problem. Self-employed individuals in a lot of businesses, like pizza parlors, for instance, are cash-driven businesses. So it's very hard to determine not only the income that's being derived, but the value of the business itself. Cash issues also create a lot of difficulties in divorce cases. There's a case, Sheridan versus Sheridan, that says if there's tax avoidance issues raised, the judge is required to report the parties to the IRS. And you may be signing joint returns and not realizing that income is underreported. But a lot of people sort of turn a blind eye to this issue. And while they say, well, I don't handle the money, many could tell, for instance, that their lifestyle greatly exceeded the tax returns that they were signing. And that becomes a problem for both of you. So, if you're in a situation where your spouse runs a business, especially if it's a cash business, you really do need additional preparation. Here, and we'll touch on that on the right side. You see, the court will generally look at a 3 to 5 year snapshot of your life. So as we go through later and talk about the information that you're going to need, you want to get about 3 to 5 years. Now, if you have a much longer marriage, 15, 20, 25 years, you might even want to do a little bit more. But at a minimum, you want to have 3 to 5 years. Here's a case, and this was an interesting one that came up, and I'll mention other cases later through this seminar, but this was an unreported case of Bardza versus Clemente. And in this case, one of the spouses was found to have transferred new property or valuable property to a girlfriend for $1. And that in and of itself is obvious what the issue is. Now, this individual later went into bankruptcy court and then tried to claim an interest in the property from the girlfriend. And the bankruptcy court prohibited him from sharing this property, and the family court prohibited him from sharing in the property because of his bad act. He had forfeited his right to this property. So the point of this case, and if you're interested in a copy, I can get you a copy, is that the court has a lot of remedies available when they find that there's been divorce planning or asset hiding. It's not just a question of bringing the asset back and dividing it. Sometimes they take the entire asset from that individual, like was the case in Bardza. And we'll see some other things. Now, this case was a little far-reaching, but the point to take from this is when a person commits an act like trying to hide an asset and it's discovered, it will often cloud most issues that follow. Judges will often say something like false in one, false in all, which basically means if you're caught lying or hiding assets, they're going to assume that you might lie about most, if not everything else. And from that point on, you're going to have an extremely uphill battle. And what you tried to gain probably wasn't even going to measure close to what you end up losing by trying that. And again, the adverse inferences that goes along with that they will draw adverse inferences probably from that moment forward. So what is appropriate divorce planning? What can or should a person do? And like I said in the very beginning of this, what you want to be prepared. There's nothing wrong with being prepared. As a matter of fact, you might even want to try to prepare with your spouse. Not every divorce is acrimonious. Not every divorce gets ugly. Some people just realize that it's time to split, and you can actually work together. So whether or not you're going to is obviously up to you, but you do want to plan certain things. First of all, let's talk about what you should do with assets. It is appropriate and lawful for a person to divide or transfer assets. I'm not suggesting that you don't have the right to do this, especially if a divorce has not been filed. But you do need to be careful why you're doing it and how it's going to look and where you put it. Um, you can, for one, talk to your spouse about dividing assets before you go into the divorce case. You're certainly allowed to make an agreement of how you want to divide assets or where you're going to transfer it. You're also able, if you want to transfer, if you're afraid that your spouse is going to try to take the assets or conceal them or keep them out of your reach, you're allowed to transfer them. Nothing prohibits you from transferring your own assets. But you need to make sure that you can demonstrate that you did it for the purpose of preserving them and not for taking them out of your spouse's reach or the court's reach. You need to be able to document what you had, what you did with it, where you transferred it, and you need to be ready and able to return it if the court should say you need to bring it back. Most of the times, like for instance, if you had a joint bank account and you transferred out half of the money, they'll make you account for it, but they may not make you return it. But if you take out all the money, they're probably going to make you return either half or all of it. So you need to be ready to do that. You can't transfer it in a way that you can't get it back. You certainly don't want to transfer it in a way that triggers a tax consequence, like cashing out your 401k, because the other side will probably argue that the dissipation or the loss that you incurred because of the tax consequence, for instance, should be borne by you. So if you diminish the value of an asset, that may come from your share of it. And savings. So safeguarding, goes along with what I was saying about transferring. You're allowed to preserve an asset. You just need to be prepared to return it. And it's not inappropriate to start saving some money, start putting some money aside, even if it's in your own name. Because again, you're allowed to have savings. This is very important for the dependent spouse, because quite often when you go into a divorce case and you're the dependent spouse seeking spousal support, it can take a very long time. It will take at least a month or so for you to get the application ready and filed with the court. It then will be another 2 months or so before you actually get a decision on that. And depending on the spouse that you have, some time after that. So you're looking at several months that you may not get support once a divorce is filed, whether you're filing it or they're filing it. So I recommend to all my dependent spouses that they start to save some money, set some money aside so that they have sort of, I don't want to call it a war chest, but at least they have something to maintain their lifestyle while they're waiting for the support order. Just be careful if you're borrowing money for this purpose or from family. One, you don't want to increase your debts inappropriately, and you also want to be able to document where the money came from and what you did with it. If you borrowed money to support yourself and now you're claiming it's a marital debt. Next, on the right side, what do you want to do about documents? What kind of documents do you want to get? Obviously, like I said before, you want anywhere from 3 to 5 years at a minimal, unless obviously your relationship wasn't that long. But I rarely recommend anything less than 3 to 5 years. You want to get bank statements, you want to get credit card statements, retirement account statements, tax returns, utility statements, anything that you can think of, you want to get. You want to collect them. You also want to start reviewing your mail. Again, this goes back to what I said before, and that is I still find a lot of people aren't fully aware of where their assets are or their financial situation. So even by keeping an eye on the mail, you'll learn where your mortgage is held. You'll learn where your spouse or your family banks. You might even see employment information, retirement statements coming. You'll also see when it changes. You'll see if you were getting statements from one bank and now all of a sudden there are new bank statements coming in. That will tip you if the mortgages have been changed or the accounts are being moved. Caller ID. If you're a working spouse, you might want to check who's calling during the day. If they're taking out new loans or transferring accounts, they're often are going to receive calls at home about that because it's usually personal assets and usually registered at the personal residence. And lastly, and probably most importantly, you want to gather documents that support the lifestyle that you led. You want to look if you got family gifts. You want to be able to show that you want to find the bank statements that show the deposits or the gift tax returns that show that you received it. If you took out loans or you have loans, you want to make sure that you have the documents, not only for the loans, but also for the payment history, which may or may not be on your bank statements. And you want to either get documents or make statements up or notes about the lifestyle that you led, where you took vacations, what kind of receipts do you have, where did you buy furniture, what restaurants did you eat at, how often did you go out, what did you do for entertainment. These are things that if you're looking for spousal or even child support are going to be documents and issues that you need to be able to address. You also want to start thinking about witnesses and proofs to support these issues. What conversations did you have with people about your vacations or your lifestyles? Who was a witness to it that you may need to call to support that? Not everything gets shown by a document. So you really need to have the sort of backup that shows the lifestyle that you at least feel that you led, that you're going to need to want to try to maintain. The next is a case information statement. Now, this is not necessarily something that you'll be preparing before your divorce. Well, actually, if you did, you'd probably be far ahead of the game, but it's a document that's required in your divorce case once you file your divorce case. But you would want to consider doing it now, or obviously as part of your preparation, because it is a very difficult, often very tedious document, but it is very, very important. Now, the case information statement is a document that's going to ask you for everything from how much your family earns a year and down to how much are your expenses, from your mortgage payment to how much you spend on hair care. It's a very taxing form to complete, but it's very important. One thing to realize, it's a summary document. So while you want it to be accurate, it's not going to be perfect. And I tell my clients, don't agonize over this document, because if you try to make it permanent or perfect, you're not going to, and you're going to drive yourself crazy. Like I said, it's important. It's the statement of your assets. Aside from income and debts, we'll have a statement of your assets and your debts, which is why you need all these documents. The purpose of this case information statement generally is for support issues, child support and spousal support. So it will be used to determine the lifestyle that you shared. And it'll have two columns. It'll ask for your lifestyle while you were married and the current lifestyle, assuming that it's post-divorce. And it's important because the hard part about this is if you have a lengthy marriage or even a marriage of many years, it's hard to say what your lifestyle was because it would have varied. You know, a lot of people take less vacations in the beginning of a relationship and more towards the end as their incomes have grown, or they take more in the beginning and less in the end because they have children. So you want to try to get an average, but more you want to reflect the current marital lifestyle, because that's the one you're going to be seeking to maintain. You will have an ability and an obligation to amend it throughout the litigation and certainly right before trial. So if there's something that was omitted, you certainly can add it, but you want to be able to explain why you omitted it in the first place and why it's significant. And future needs. You want to build into it, if possible, what your future needs are going to be, both you and any children, because it's going to be used by the court, as I said, to determine support. So you need to look at what your future needs are going to be. Now, there's a certain way in the document that allows you to put in both what is current, and you can sort of footnote for anticipated expenses, or maybe you're going to get certain expenses that you don't have right now once you get divorced. So you can put all this in. It's very important. I usually recommend, even if you're not going to have a lawyer for your divorce litigation, that you at least sit with one to understand the case information statement and how to fill it out, because it's going to be the most important. You can and also should attach statements to the case information statement to support it. You can attach anything you want. You can put in bank statements and tax returns. You can put credit card statements, appraisals, anything that you want can be attached to this, which helps to sort of summarize your information. The more you put in your case information statement, the better picture the court's going to have of the lifestyle that you're presenting. All right, so preparing for divorce litigation. Now, some of this I did touch upon, so I'm just going to go quickly through this. This is really mini list of at least what you want to have for your document preparation. Um, and again, 3 to 5 years. So you want to have bank statements for current and past accounts, even if they're closed, credit card statements. Usually you can get several years of these back if you don't have them, because that will show not only the debts, but it will be good to show you the lifestyle. Utility bills will show the consumption that your family had and what your needs are going to be. Retirement account statements will not only document the value, but it will also show if there's any loans that have been taken. Tax returns, obviously very important, probably one of the most important, because it'll not only show your income, but it also shows taxable events. So if there's taxable interest, then that suggests that there are or were interest-bearing accounts. If there's 401k or retirement account that was closed, you're going to pick it up as income. other other accounts, like stock accounts, will trigger capital gain issues, which will appear on tax returns, which will also help you trace assets. So do what you can to get at least these minimal statements together before you even go forward on a divorce, if you are the one that's actually going to be filing. Now, the next is I want to talk a little bit about a QDRO. It's a qualified domestic relations order. Now, this is generally something that's done at the very end of a divorce case, but I try to encourage clients to do this in the beginning. A qualified domestic relations order is a court order that allows a pension plan or a retirement account that's held by one spouse to be physically, almost legally divided into two accounts so that the non-contributing spouse can get a share of it, because the retirement account is for the employee. And federal law has a lot of protections against retirement accounts. So in order to actually get a share of your spouse's retirement accounts, in most cases you will need a QDRO, which is what's referred to, a QDRO. The reason I suggest doing it beforehand is pensions are very complicated. Um, they're not always entirely marital accounts, excuse me. So you will often need to hire an actuary to review the accounts and determine what is marital and what was not marital. And it's not just the dollar amount, because certain retirement accounts are based on the value of the shares purchased. So if you buy a share of stock that's in a retirement account in 1990, that share may go up and go down. You buy another share in 1991, and that share is going to go up and down, but differently than the first one, because you bought it at a different time. And that's the nature of most retirement accounts. The shares that make up the account differ, and you need to have somebody that's going to determine what share is yours and what is your spouse's. And you want to also watch for loans, because a very common way that people not only plan for divorce but also just take money out of assets is by taking a loan. Loans do not appear on tax returns. They will only appear in either the retirement statement or sometimes on paychecks. So you want to know when money was taken out, because you want to know what it was used for. Some cases they would have taken a pension loan because you needed a new roof, and others they took it out because they put it into a shoebox, and they're not going to disclose it. So you need to be able to track it. By doing the QDRO early and getting retirement accounts early, you can address these issues and have more time to investigate them. You don't want to get a QDRO after your divorce case is over and then find out that there was a loan against it that you didn't account for, and now you can't go back and handle it. And again, I always recommend hiring an actuary. There's a couple of companies, I can give you names afterwards, I recommend. Very, very good at handling these accounts. It's all that they do. It's rare that lawyers will do this on their own. They will almost always hire a company to do it. That's how important and how difficult it can be. And next, you want to also start to try to determine what your lifestyle is and what your support needs are going to be. And that's often a very challenging situation, because, again, it changes year to year. It may be better or worse now than it was in the beginning of your relationship. You may have significant changes in the future. Child-related responsibilities will change. And so you need to start taking all this into account. You need to start looking at the marital standard of living. from year one until the year that you're getting divorced, as far back as you possibly can. I know I've said at least 3 to 5 years, but it varies. Um, but the purpose of support in most cases is that the dependent spouse lead a comparable lifestyle that he or she had while they were married. Well, you need to know what that lifestyle was in order to know what's comparable. And remember, comparable is not equal or even, it's not exact. So there's always going to be a diminution of the lifestyle because one house is divided into two. So usually taking this one income in one house and putting it into two houses. So to get as comparable of a lifestyle as you could, you need to have not only the documents to show it, but you need the knowledge of what your lifestyle was. You need to be able to explain it. Should your case not settle and you find yourself explaining to a judge. Obviously, the goal is, like I said, to preserve your marital standard of living. Now, here you'll see a couple cases we mentioned. Weishaus versus Weishaus at 360 New Jersey Super, page 281. It's an appellate division case from 2003. And this is really the first main case that talked about determining the marital standard of living, as well as determining how and the resources that were used to reach it. It becomes difficult in most cases. We'll settle by an agreement, so you don't usually get this thorough of an analysis that you will inside of a court, but there's nothing that prohibits you from doing it yourself. Really taking a look at how you lived during your marriage and how you were able to live that way. Did employment change? How did you use credit cards? How did you budget your money? And that turns us to the next case, also Hughes versus Hughes at 311 New Jersey Super, page 15. That was an Appellate Division 98 case. And that case basically said, you look at how the family actually lived, meaning not just how much did they earn, but how did they live on it? Did they borrow money or get gifts from the family? Did they use credit cards or borrow loans or avoid paying their bills? The Hughes case actually stands for the proposition that if a family lived a certain way, whether it was by borrowing money or living on credit cards, the court can continue that lifestyle or can order the higher earning spouse to continue that lifestyle because it was their lifestyle, even if there aren't actual means for it. So basically, it's saying if you lived on credit cards, court may say you need to continue doing that to support the lifestyle that you created. Now, in my experience, that doesn't really happen too often. The courts will still usually take you where you are, unless there's, again, issues of planning or diverted assets. So when there are things, if you did get family gifts or borrow money or use credit cards, this is where planning is very important. You need to get the documents together. If there were loans taken out, if family loans, you need to show whether or not there was repayment schedules or an intent to repay. Write down the conversations you had about these issues. Did you talk about credit cards? Did you talk about loans? Did you talk about the debt that you were incurring? This is an important case if you live either way beyond your means and you're looking to reduce that, or if you're the dependent spouse and you want to maintain it, you need to be prepared. And you also need to be very conscious of how your and your family's needs are going to change in the future. One, if you're the non-working spouse, alimony is obviously going to be a huge issue. You need to determine early, are you going to rejoin the workforce? Are you going to go back to school to pick up a new skill or to finish your degree? There are different types of alimony. The different types of alimony last for different amounts of time. They can be modified for different reasons. So the type of alimony that you get will greatly determine the future of your alimony, whether or not it continues or not. So you may need a plan. Even if your plan is that you're not going to do anything, you need to know that why that is. And that turns a lot to child care responsibilities. Well, actually, before we even get to that, part of the reason why you may not be looking to make a plan could be that you've been out of the workforce for so long that you'll never reach a comparable level of where you might have been, sort of economically disadvantaged from being absent. Technological changes have progressed in such a way that you'll never make that kind of money. Going back to school is just not going to make any sense. But those are reasons to consider arguing that support is needed and that you're not going to return to work. And if you're going to be making this argument, you need to be able to support it. But more importantly, the common reason is childcare responsibilities. You may right now have or not have daycare or aftercare. You have to look at how is that going to change. Do you have young children that will be going into daycare? Do you have older children that will be coming out of daycare and that you need to be available for? You also need to look at what are their lives going to consist of in the future. And I put in here extracurricular activities, and because that's not included in child support. I'm sorry that I have that backwards. That's included in child support, meaning unless you have an agreement otherwise, the non-custodial parent will not be contributing to extracurricular activities. It's considered to be a part of the child support that you will get, and it's generally insufficient. With the current way that most people raise their children, there's a great deal of extracurricular activities now that didn't exist 10 or 20 years ago. I believe that extracurricular activities have become a sort of daycare for children because you can't have them outside playing ball in the park like you used to 20 years ago. So you need to look at what are those activities going to be? What special skills or needs do the children have that they may grow into? What activities do they engage in now that may grow? Like, do they play? Are they an exceptional baseball player where they might start, touring and having, championship series? These are all things that are going to be changes in your future that need to be built into your case information statement. College expenses, and I cite the case Newberg versus Rico, 88 New Jersey Super, page 529. That case sets forth the criteria for college contribution that the courts will look at when ordering the non-custodial parent to contribute to college. A very important case if you believe that your children will be going to college, even if it's many, many years down the line. You want to take a look at this now. You don't want to wait until they're applying to schools to find out that we don't have the money for it. You may have young children and you might want to start a 529 case or a 529 account inside of your divorce. Well, you need to be able to show the court why that's in the children's best interest and why that should be part of the divorce case, even though it's many years away. And that can only be done if you plan for it. Expert costs and fees. Another thing, again, and you may want to speak to a lawyer. One of your experts I mentioned in here is a lawyer. Experts are very important in divorce cases, and most people wait until they find that they need one to actually hire one. And then you have very little time to interview, very little time to consider, less time to get the monies together. So I always recommend that the best way to prepare is to research and look for referrals now if you think you're going to need different experts. You're going to have, depending on the nature of the case, you could have experts for appraisals of assets. There's real estate appraisals, business appraisals, personal property like jewelry and personal collection. If you have these assets and you want the court to divide them for you, you have to be able to show what they're worth. And you don't want to rely on your spouse to present that evidence. Custody. If you think custody is going to be an issue, you may need an expert to show which parent the child has bonded with. It's called a bonding analysis. You may need somebody to show whether the other spouse is fit as a parent. You may have children with special needs that you need to present. These are not experts you want to be getting last minute. You really want to be able to talk to people and find out about your experts. Employment. You may need an occupational to say either that you can't work a certain amount or to show that your spouse can work. If you have a spouse who isn't working, it's not just sufficient to say, well, they could work. You need to be able to show how much they would earn. And without somebody who's an expert in that area, the courts may not accept any testimony. And lastly, legal fees. I obviously always recommend having a lawyer, not because I am one, because it's a very difficult process and you really want to have some independent guidance. But you don't want to jump in and just take any lawyer. You don't want to just go because your sister used the lawyer or because your real estate broker told you this is a good person. You want to take some time and interview lawyers. You're going to be going through what could be a very difficult, lengthy process. You want to make sure that the person you have going through it with you is a good fit. And you also know, for all these experts, you also want to know what the costs are going to be and how you're going to plan for that. Now, that may end up being different once your case starts, but you want to, again, go in there prepared for what you're going to be facing. Now, let's look specifically at custody professionals because these are very important. They're very complicated and they can often be very expensive. Now, the reason I'm focusing on these specific ones, and I have therapists, parenting time coordinators, um, these fill a different role and often will arise either during a litigation or sometimes even after a litigation. But you want to be aware of whether or not you think you're going to need them in your case. And generally, you're going to need these either if you have a child or children with special needs or you have a high conflict case. Therapists, any high conflict case will have an impact on the children. No matter how great a parent you are, no matter how much you minimize their involvement or connection, it's going to have an impact. Divorce itself always has an impact. High conflict always has an impact. So in many circumstances, having a therapist is very helpful. Now, if you're going into a divorce, you might want to get a therapist for your child first because you can do it without you have unfettered discretion before you file a divorce. If you're inside a divorce and you want to get a therapist, you can't necessarily just take your child to a therapist and tell your other spouse this is what you did. You're supposed to include them in the decision. The courts will often make the decision of who the therapist is going to be if you can't. So if you think your child's going to need a therapist if you think they're going to need a therapist in a divorce case, I'd recommend you start interviewing them and maybe even bring them to a therapist before you start the process. So that way they've begun the treatment. Courts are less likely to interfere with an ongoing treatment for a child because that's just very disruptive to the whole process. So getting it first will usually like to continue, and then it's also the therapist that you prefer and choose. Now, parenting time coordinators usually come about either in a divorce case or after a divorce case, and generally on high conflict cases. They are neutral third parties that are either ordered by the court or the parties pick them. And the purpose is to be an intermediary for parenting decisions. What they do is they hear both sides to an issue and then they make a recommendation. Now, its recommendation is not binding, but it can be submitted to a court later if the parties don't accept the recommendation. It's persuasive to the court of how the decision should be made. I have mixed feelings about parenting coordinators. In some cases, they're very helpful. In some cases, they don't help high conflict cases. They're just another way to create conflict. But if you think you're going to need a parenting time coordinator, if you think you're going to have a high conflict custody issue, you might want to start interviewing people beforehand to see who offers that type of service and who would be the best fit for your case. Asset protection. I know I said in the beginning, about being very cautious if you're going to do anything with assets. But there are certain things to do with the assets that you have, or not to do, I should say, possibly, with assets that you have to ensure that you don't affect adversely your divorce case or your share of these assets. First of all, and I can't say it enough, you got to compile account statements. You want to get as many as you can, as far back as you can. The second is to consider a litigation fund if you think it's going to be needed and where it might come from. A litigation fund is a common remedy courts set up when there's usually a high conflict or complicated divorce and the need for a lot of expert fees and a lot of legal fees, that the court will often take an asset and have the parties take a certain amount of money out of it and use it as a litigation fund. If you think this is going to be the case in your case, then you want to try to consider in advance where that might come from because you want to be able to control it. Most commonly, courts will do it from a home. That's generally a person's bigger assets. Historically, it was easier to get loans against it than it is right now, but it's generally where the courts will turn to first. And the problem there is if you're the dependent spouse looking to keep the home, if you take money out to create a litigation fund and encumber their home, it's going to be more difficult for you to take it. Now, the flip side is if somebody's planning a divorce, they may want to do that specifically to prohibit you from taking the house. So you want to know what other assets would be available to use this litigation fund so that it doesn't have such an impact on your future needs. Next is to be wary about commingling assets. And I don't mean marital assets. This topic's a little broader than I can really get into in this topic, but there are assets that are marital assets and assets that are not marital assets. Not, assets that are not considered marital assets would be lawsuit recoveries, inheritances, lottery winnings, gifts. So if you've received these or you're going to receive these types of assets, you do not want to commingle them or put them into joint names. In many cases, when you do that, and the two cases I cite here, Wadlow versus Wadlow and Ryan versus Ryan, are examples when there was commingling. If you commingle an asset, you lose the separate property identification. It's not identified as your property anymore. It now becomes a marital asset. Now, there's one caveat to that caveat, and that is some cases will hold if an asset was commingled merely for convenience, then you may not lose its separate identity. So, for instance, if you received a large personal injury lawsuit settlement and you put in joint accounts because you needed your spouse to pay bills with it, or you were going to be hospitalized or out of the country and they needed to have access to it, then you could argue that that was for convenience and the intent was not to commingle. And again, this goes back to what I keep saying. And if this is going to be an issue, you need to be prepared with witnesses and statements and documents that evidence whether it was or was not a convenience, no matter which side of this argument you're going to be on. And again, if you're the spouse that did not handle the assets and finances, then you're going to be at a disadvantage when these issues come up if you haven't investigated them and prepared for them beforehand. Okay, now I told you in my title we were going to discuss some common myths and misconceptions. I'll try to shed a little bit of light onto them and tie into why or why they are not significant for planning. The first one that I hear often, or people say often, that they can hire transfer assets to keep them from being distributed. Completely not false. As I said in the very beginning of this, and I'm going to say it to my grave, you can't. And if you try it and you get caught, it's going to be far worse than if you did it. Most people, again, if you have a significant amount of assets, you're never going to be able to hide them. And if you have a small amount of assets, there's nothing to hide. The damage you do in reputation and adverse findings will greatly outweigh any amount of money you thought that you were getting and keeping outside of the court's reach. There's a case, Reed versus Reed. I don't have the site in front of me now. It's an unreported case. If you're interested in, email me and I'll send you the site. This was a case where the spouse had transferred assets and withdrew assets to such a substantial level that the court actually denied that person alimony. So this was a dependent spouse, and what this person was doing, but on a very large level, a lot of people do, and even short of what I recommended, but obviously an egregious level, was to start. I recommend if you're a dependent spouse, start saving some money. Well, this dependent spouse started stealing money and dissipating assets, and it was so egregious that the court, which again is a court of fairness, said then you don't get alimony. You've gotten your share, and that's all that you're going to get. Second issue, and this is very common in both divorces and in just family matters, and that's people believing that they can quit their job and not pay support, or a spouse worrying that the other spouse will quit their job to avoid paying support. And that's not going to happen. There's a plethora of cases. One is Kaplan versus Kaplan, 182 New Jersey Reporter, page 250. It was a New Jersey Supreme Court case in 2005. In that case, as well as countless other cases, hold the premise of imputed income. Basically, if you have an income history, then and now you've decreased it, the court will impute your work to that level, whether or not you're actually earning it, unless you can show with an expert and for good reason that you cannot earn that kind of comparable level. Imputed income was created basically so, like, if you're a doctor and you're making a couple $100,000, you can't just quit your job and start pumping gas because you don't want to pay support. The court will put you at the level that you should be earning, whether or not you are in fact earning it. Next concern a lot of people have is that if there's infidelity, that they won't get alimony. or if the other spouse was unfaithful, that they don't have to pay alimony. Not the case. It may be the case in Pennsylvania. I'm not sure. I did hear some, but in New Jersey, it has nothing to do with it. Unfortunately, in some cases, um, it could be hurtful if you were the supporting spouse and you find that your other spouse was having an extramarital affair and now you're forced to support them. Um, so this is not an issue that you need to really prepare much for. I mean, it's rare that it's going to have any impact on your case, unfortunately, but it's the way it is. Next is about a lot of people think that they cannot move out of state with their children without consent. Now, this is a very tricky issue because it's different depending on if it's before or after your divorce case is filed. If it's before, you can, just like your other spouse can move without permission. It's once there's litigation filed, a divorce case or child support or custody, anything that puts custody before the court, you then need either the other spouse's permission or the other parent's permission or the court's permission. And this goes to planning. There are many, many guidelines. There's a case called Bowers versus Lewis. Again, if you want the site, I can send it to you. Just send me a message. That sets forth about 14 different criteria that you need to establish to move out of state. Now, ultimately, the court's going to look to if you have a good faith reason for the move, that it's not going to harm the child, they will let you relocate. But again, you have to be prepared to show that it's in the child's best interest. And I don't recommend just walking into a divorce case or a relocation case and saying, this is what I want to do. So relocation, very important to prepare for, similar to what I've been saying throughout this session. Next one, if you leave the house, it's abandonment. A lot of people often tell me, or they've made decisions based on this kind of a concern. They don't want to lose an asset. It is not the case. You are free to move out of a house. Your division of assets and debts will be divided by what's called equitable distribution, based on what's fair, not based on who's living in it, not based on whose name it's in. That doesn't affect the distribution of your assets and debts. But if you are going to leave your house, again, as far as divorce planning goes, make sure to copy any statements that are in there, because once you move out, you may have a great amount of difficulty getting the statements back from the other spouse. And then it's a very difficult burden to get your own documents, and it slows down your preparation. The last is, a lot of people say, well, the law favors women or it favors men or mothers or fathers, whatever it should be, depends on where you're standing. And people say, well, they throw their hands up. There's no reason to prepare because my wife's going to get alimony, or I'm never going to get custody of the children. It's not the case. The law does not favor any person or gender on any issue. It favors the best interests of your children, and it favors what's equitable to divide your assets and debts and to set support. So any issue, whether you want alimony or you want custody or there's domestic violence, will be determined based on the facts of your case. And the facts of your case will only be demonstrated by preparation, by having the documents that I recommend, by having the witness list, by having conversation notes, so that you're able to show why you believe your position is the one a court should adopt. Okay, with that, I'm going to take a second and close down the recording so I can take some questions. Give me just another second or two, and I will be ready for everybody, and I'll read any questions that came up, as well as any ones that you may still have coming.